Hello and welcome to this week's special Independence Day episode of Legal Wrangle on Corp Laws. Now, dishonoring of check is an offence, and to ensure the trust in transferability of check, Section 143A and Section 148 were introduced in the Act of 1881 by the Amendment Act of 2018. What makes Section 143A special is that it compels the drawer or issuer of check to pay the complainant during the pendency of criminal complaint a maximum of 20% of the amount of check as interim compensation, while Section 148 compels the drawer to pay interim compensation during the pendency of appeal from the order of trial court. Hence, Section 143A provides for interim compensation in pre-conviction stage, and Section 148 provides for interim compensation in the post-conviction stage. Now, the Apex Court recently has classified in the case of Surinder Singh Deswal that Section 148 is applicable retrospectively. But can the same interpretation of retrospective effect is applicable to the provision of Section 143A? This question for a while has confused the litigators who are already litigating check bounce cases filed before the amendment was introduced in September 2018. The Supreme Court has now put that question at rest. The appeal was filed against the order passed by the Madras High Court in February 2019, where the court reduced the interim compensation payable by the appellant Mr. Raja from 20% to 15% of the check amount. Earlier, Mr. Raja issued 2 checks in the name of Mr. SURANA, the respondent, which were dishonored on account of insufficiency of funds. The complaint was launched in November 2016, which is currently pending before the Fast Track Magistrate Court, Chennai. The magistrate, soon after the insertion of Section 143A by the September 2019 amendment, ordered Mr. Raja to cough up 20% of the check amount to be payable to Mr. Surana. When the matter reached the High Court, it said that there was no infirmity in the order which took Section 143A into consideration and applied it retrospectively. Now, 3 questions emerged before the Supreme Court were: firstly, whether Section 143A is retrospective in operation. Secondly, can it be invoked in cases where the offences punishable under Section 138 were committed much prior to the introduction of Section 143A? And finally, are the courts justified to apply the interpretation given to Section 148 to the provisions of Section 143 as well? Answering the first question in negative, the Supreme Court explained that the provisions contained in Section 143A has 2 dimensions. First, the section creates a liability for an accused to pay over 20% of the check amount to the complainant. Until this point, the guilt of the accused has not been determined. Second, it exposes the accused to coercive methods of recovery of such interim compensation through the machinery of the state, as if the interim compensation were arrears of land revenue. Prior to this, there were no provisions to compel the accused to pay compensation before the pronouncement of the guilt. The imposition and the consequential recovery through the modalities of Section 421 or Section 357 of the CRPC arose only after the person was found guilty. This was changed by the introduction of Section 143A. The accused is then subjected to a new disability. Answering the second and third questions also in negative, the Supreme Court held that while provision of Section 148 applicable after the pronouncement of guilt depended upon the existing machinery without creating any fresh disability of similar nature created by Section 143A, the interpretation of both the sections rests on a different footing. Therefore, to remove any further doubts, Section 143A is applicable only where the offence was committed after the amendment was introduced to the Negotiable Instrument Act in 2018. Moving on, another interesting issue came up for consideration before the High Court of Madras on 23rd of July 2019. Section 141 talks about offences by companies and makes liable the company as well as all the directors who at the time were responsible for the company. The definition of company includes a partnership firm and the definition of director includes a partner in the firm. But what happens when an unregistered partnership firm issues a check and gets its dishonored? Does that mean that only partners in the firm can be made accused since legally the firm is not registered? Does an unregistered partnership firm is outside or within the purview of Section 141? Let's find out. Mr. Ramesh, who was an ex-partner in the firm named Lakshmi Agencies, was issued a check against certain dues payable to him on retirement. That check got bounced and a criminal complaint against the petitioner under Section 138 of the Negotiable Instrument Act was filed by Mr. Ramesh. The check was issued on behalf of the unregistered partnership firm and not by the individual partners. However, Mr. Ramesh directed the complaint against the partners in their capacity as individuals without making the partnership firm as accused. The legal ground taken to omit the name of the firm was that since the partnership firm was unregistered, it was not a recognizable legal entity. Therefore, as per Section 69 Clause 2 of the Partnership Act 1932, there was no requirement to make the partnership firm an accused in the complaint. The High Court held that the concept of vicarious liability under Section 141 is applicable to partnership firms regardless of their registration status, making it compulsory for the complainant in check bounce cases to make the firm as well as the partners accused in the complaint. The grounds given by the court were: first, check bounce case is a criminal case and hence when the provisions of criminal law are interpreted, the concept of strict construction will apply. Chapter 17 of the Negotiable Instrument Act is a code by itself. A penal provision in that code entails a conviction and then sentence on proof of guilt. Third, this outs the readability of Section 69 Clause 2 of the Partnership Act with that of the provision of Section 141 of the NI Act. This is for the simple reason that a civil provision of suit cannot be stretched to criminal prosecutions. For all those reasons, the registration or non-registration of the partnership firm will have no bearing insofar as Section 141 is concerned. In a nutshell, a statutory notice in the name of partnership firm is compulsory when a notice is issued in the name of its partners. The complaint filed by Mr. Ramesh was therefore found unsustainable. That's it for today's special episode on NI Act. If you want more of cases of Companies Act, market laws, competition laws, IPR, PMLA and FEMA, log on to www.tiolcorplaws.com to find out more. Happy Independence Day and thank you for watching.